Alright, so you can see the screen, and also you should actually open up your site as well, okay, because so that you can actually scroll around yourself as well. Okay, so is yours open? Yours open already?
Yeah, I printed already.
Oh, printed it out as well. Okay, good. Okay, so this is paper 2 data response May June 2020 set 3, and this is question 2. Okay, so this one we are going to read the whole thing one time first and then see whether you have any problem or not. Okay, usually students will have problem with the source material, okay, not really the scenario itself, although the scenario students might actually get confused. Okay, so I'm mentioning this because actually this is actually the first time that I'm going through with you paper 2 data response. Okay, so I'm not really sure how you actually tackle data response question yet. Okay, so I need to mention this thing. Right, so just read through just very fast. Okay, right, so you can look at my cursor. Okay, right, question 2a. Kate wants to bring a case against her employer, Bill, an employment tribunal, so she completes and sends the prescribed form. The tribunal agrees to hear her claim and sends her form and a response form to Bill, telling him he has 14 days to reply or lose the case. Bill sends a letter to Kate and to the tribunal 10 days later, requesting an extension because he is ill. Kate writes to the tribunal 2 days later opposing the extension, but the employment judge grants Bill's extension without a hearing. So explain how the tribunal's rules of procedure 2013 will apply to Kate. Right, firstly, any problem with question A?
No.
No. Alright, let's move on very fast. Okay, question B. Paul's dispute with his employer Charles is to be heard in an employment tribunal on 10 June. On 5th June, William, a key witness, sends his evidence to the tribunal and to Paul in writing, as he cannot attend the hearing. Charles gives his evidence by telephone through loudspeakers so that everyone can hear him. The tribunal panel is made up of 3 people and 2 decide in Paul's favor. Their judgment explains how the law has been applied, and the financial award sets out what Charles must pay Paul. Explain how the employment tribunal rules of procedure 2013 will apply to Paul. Alright, any problem here?
No.
Alright. Okay, next one. Amir is bringing a case against his employer, Sheena, in an employment tribunal. He sends a prescribed completed claim form to the tribunal. It rejects one of his claims, but sends the other to Sheena with the response form, which she completes and returns. On the day of the hearing, Sheena's husband, Hamish, represents her as she has been admitted to hospital. The tribunal gives Amir an hour to present his evidence. After an hour, Amir is still presenting evidence, but the tribunal tells him they have heard enough. There is a unanimous decision in favor of Sheena. Okay, same question here. Right, any problem with the scenario?
No.
Alright, good. Okay, now let's go through the source material one time. Okay. Right, source material for question 2, the Employment Tribunal's Rules of Procedure 2013. Rule 8, sub 1. A claim shall be started by presenting a completed form using a prescribed form. I don't think there's a problem here, right?
No.
Right, next one. Rule 15. The tribunal shall send a copy of the claim form together with the prescribed response form to each respondent with a notice which includes the information on sub A, whether any part of the claim has been rejected, and sub B, how to submit a response to the claim, the time limit for doing so, and what will happen if a response is not received by the tribunal within that time limit. Okay, any problem here?
No.
Alright. Okay, rule 16, sub 1. The response shall be on a prescribed form and presented to the tribunal office within 28 days of the date that the copy of the claim form was sent by the tribunal. No problem here?
No.
Alright. Rule 20, sub 1. An application for an extension of time for presenting a response shall be presented in writing and copied to the claimant. If it shall set out the reason why the extension is sought and shall, except where the time limit has not yet expired, be accompanied by a draft of the response which the respondent wishes to present, or an explanation of why that is not possible, and if the respondent wishes to request a hearing, this shall be requested in the application. It's a mouthful here. Sub 2. The claimant may within 7 days of receipt of the application give reasons in writing explaining why the application is opposed. Then sub 3. An employment judge may determine the application without hearing. Okay, so there's a lot here. Any problem?
I think the only problem in this page was what I got with 20 sub 1.
Okay.
Because does it mean that if, let's say, the time limit has not expired, then he doesn't need to set out why the extension is sought?
Where exactly are you getting this from?
Right there. Yep. Stop there.
Here. It shall set out. Okay, it shall set out the reason why the extension is sought and shall accept where the limit has not expired, be accompanied by a draft response which the respondent wishes to present, or an explanation of why that is not possible if the respondent. Okay, it is basically can. Okay, they basically say that they must give reason. Okay, why, okay, they want an extension and all that. Then after that, okay, sub 2 and sub 3 only says that, okay, that the claimant may within 7 days, okay, how to say, get the application opposed. Okay, understand? So you need to, I need to read both sub 1 and sub 2 together. Sub 1 is just saying that, yeah, okay, you can actually try to delay it or whatever it is. Okay, all right, time extension here. Okay, all right, you need to give out reason, blah blah blah, whatever it is. Okay, but at the same time, okay, the claimant also has a reason, okay, to actually oppose it within 7 days, and then the judge can also do whatever it is that he wants to do lah. Okay, are you okay with the explanation?
Yeah, okay.
Okay, well, but I think later when we try to apply it, then we see how lah. Okay, all right. Rule 42. The tribunal shall consider any written representations from a party, including a party which does not propose to attend a hearing, if they are delivered to the tribunal and to all other parties not less than 7 days before the hearing. Any problem here?
No.
All right. Okay. Rule 45. Actually, this one is a lot. Okay. 45. Yeah. A tribunal may impose limits on the time that a party may take in presenting evidence, questioning witnesses, or making submissions, and may prevent the party from proceeding beyond any time so allotted. Any problem here?
No.
Okay, so this imposing the time limits already. Okay, right. And rule 46. A hearing may be conducted in whole or in part by use of electronic communication, including by telephone, provided that the tribunal considers that it would be just and equitable to do so, and provided that the parties and members of the public attending the hearing are able to hear what the tribunal hears and see any witness as seen by the tribunal. Any problem here?
See any witness means visually,
Yes.
or just like hearing?
It's basically just saying that it says like as if, okay, right, that they can hear and see the witness, or that means that, you know, if they were to want to do want to conduct it, okay, by use of electronic communication, okay, it must be done in a way where basically, you know, everybody can hear and see the witness there, okay. It's like as if you can hear and see the witness there. So it could actually be like, you know, like how they do video conferencing and stuff like that lah. Either that, or it's like through a phone or something, a loudspeaker or something like that. Okay. After all, this one was made in 2003, so I guess it also includes things like the video conferencing lah. Okay, but I don't think it need to be too concerned with that. Okay. Important thing is that I can hear and can see, okay, despite using electronic communication. Okay, right, I'm going to finish already. Rule 47. If a party fails to attend or to be represented at the hearing, the tribunal may dismiss the claim or proceed with the hearing in the absence of the party. So before doing so, it shall consider any information which is available to it after any inquiries that may be practicable. about the reason for the party's absence. Okay, any problem here?
No.
Alright, good. Okay, rule 49. Where a tribunal is composed of 3 persons, any decision may be made by majority, and if it is composed of 2 persons, the employment judge has a second casting vote. Any problem here?
No.
Alright, okay, last one. Rule 61 sub 5. In a case of a judgment, the reason shall identify the issues which the tribunal has determined, state the findings of fact made in relation to those issues, concisely identify the relevant law, and state how the law has been applied to those findings in order to decide the issues. Where the judgment includes a financial award, the reasons shall identify by means of a table or otherwise how the amount to be paid has been calculated. Any problem here?
No.
No, alright, good. Alright. Alright, so what we're going to do now is to answer each question individually. But before we can answer each question individually, okay, usually for data response question, okay, it'll be good to actually highlight or to like take note of key points and keywords and stuff like that from each and every scenario, okay, and then we try to find out, okay, how we can actually address those issues by using the source material, okay. Right, so from here, question 2a, alright, can you just highlight to me what is relevant?
Complete and sends in the prescribed form.
Complete and sends the subscribed form. Okay, what else?
Sends her form and a response form to fill. Sends her form.
Okay.
Yeah, around there.
Okay, no.
To the tribunal 10 days later, requesting an extension.
Bill sends a letter to Kate. Okay, so I think this whole thing here.
Kate writes to the tribunal.
Sends a letter to Kate and to the tribunal. Yeah, this whole thing lah. Okay. Okay, and then this one, Kate writes to the tribunals opposing. Okay, 2 days later. Alright, anything else?
Without a hearing. Employment judge grants without hearing.
Oh yes, the last part here. Okay, so I guess that's about it. Okay, so quite a lot here. Okay, it depends. Okay, sometimes I mean there's a lot, sometimes there's very little things. Okay, sometimes very straightforward, sometimes it's a bit more complicated. Right, never mind. Now I'm sure you can look at your own thing already. Okay, so which part is relevant? Come let me know, and then we'll try and highlight it, and then after that once we can get a conclusion already, we look at the marking scheme and then see whether is it correct or not. Okay, so which one is relevant first?
This question A in particular is Rule 8.15.
Sorry? Rule 8.
Rule 8.
Okay, so Rule 8. Okay, that's one by one. Okay, why is Rule 8 relevant?
To the first one, completes and sends in the prescribed form. So basically, she just completed the form.
Okay, so it's this one lah. Alright, you can see my cursor right here. Huh?
Yep.
This area.
So she officially started the claim.
Alright, okay, good. Okay, what else?
And sends her form. Wait, what am I saying? Rule 15.
Okay, which one? Which one in particular? I mean, any key points? I mean, definitely not the whole thing, right?
I think Rule 15 sends in. It's just the top only. Shall send a copy of the form and the claim form together to each respondent.
Okay. Alright, basically this whole thing here, yeah.
Yeah.
Okay, but anything here, sub A, sub B?
No.
No lah.
Not mentioned here.
Alright, it's just something general only lah. Okay. Right, what else? Next one?
20 sub 1.
20 sub 1. Anything in particular here?
Let me see. Mention. Application for an extension?
Yes. Okay. So you can see how is it like one by one. Okay, we apply it. Okay. Alright, so application to okay, right. There might we just highlight first and later I'll try to summarize it. Okay, so what else? Anything else from here?
20 sub 2 within 7 days.
Within 7 days. Okay, this one is opposing.
Yeah.
Alright, okay, anything else?
20 sub 3 without a hearing.
Okay. Alright, anything else before I summarize it?
No.
Nothing lah. Okay, so just very fast. So rule 8 sub 1 is basically referring to basically referring to how Kate, okay, right, complete the form and send it, okay, right, so no problem there. Then the next one, rule 20, an application for extension of the time, is where Bill sends a letter to Kate, requesting for an extension. Okay, so I hope you can see my cursor here. Okay, all right. Then after that, where is it? Okay, the claim may within 7 days of receipt. Okay, application is opposed. Okay, sub 2. So this one here is Kate. Okay, then lastly, employment judge may determine the application without hearing, sub 3. Alright, so at the end of the day, okay, will it apply in Kate's favor or not? What do you think?
Actually, I don't know what the question is trying to ask me.
Yeah,
How will you?
Yeah, I know it's actually kind of vague, right? But how will you conclude it at least? How will you conclude it? Will you like just state all the things? Because at the end of the day, you need a conclusion. So because the question also did ask okay, how will it apply to Kate? So if you were to ask questions like this, right, okay, usually it means whether you help her or not help her, something like that. So based on that understanding of the question, okay, so that's why I'm asking you, okay, do you think that it will be in her favor or not?
No, I shall have to wait. I mean, the decision is already out, so she has to wait for Bill.
Okay, alright. Okay, now let's look at the marking scheme and then see whether is it correct or not. Okay. Alright, so I'm assuming that this is the first time that you actually look at the marking scheme. Right, we'll just look at band 5 lah. Okay, you can see my cursor. Look at band 5. So I'm just going to read through the whole thing first. Okay, full development of the relevant sections. Okay, conclusion is that Kate will have to wait for Bill to get better. So that was your conclusion there. Okay, she has made a valid application under Rule 8, which you did mention just now. The tribunal's response meets the requirement of Rule 15, which did you mention? Got okay, basically it's just a general thing lah. Okay, good. Okay, just not forgot to highlight this thing when I was summarizing it. Okay, never mind. Where is it? Okay, then after that, Bill's letter appears to meet Rule 2 sub 1 as he explains why he cannot respond. Okay, he needs to delay and all that. Okay, then Kate's opposition sub 2, but the judge decision under sub 3 appears to be valid as it can be done without hearing. So I guess your answer is correct. Okay, the only problem is that with regards to the conclusion there. So usually okay, nowadays if you were to see the marking scheme for the data response question, usually they will start something like this first. Okay, it's usually the same. Okay, later we look at the rest, is also the same. Okay, they say full development of relevant section, then conclusion. Okay, right, so that's why it is imperative, okay, that you have a conclusion. Okay, and the conclusion must of course reflect the question itself lah. Okay, and because the question says, okay, explain how the employment tribunal's rules of procedure 2013 will apply to Kate. So basically you just need to explain how it will apply to her. Okay, or in other words, okay, whether it applies in a way which is favorable or not favorable to her. Are you okay with that?
Yep.
Alright, okay, now let's look at question B. Okay, can you just highlight for me anything first, anything relevant?
Oh, this one very short only. 5 June, William.
Sorry, hold on now. 5th June, okay, key witness.
Yep.
Wait, I think I better change the color here.
Sends evidence in writing.
Hold on now. Okay, 5th June, okay, key witness, then what else?
Sends evidence in writing. Wait, just, I think you highlight in writing就okay了.
Okay, in writing here. as he cannot attend the thing, right? Why is the thing?
Yep.
Okay, then what else?
Charles
gives
gives evidence through telephone
through telephone.
with loudspeakers.
Wait. I need to how to. Okay. I know how to do it. Okay, alright. Through loudspeakers. Okay, what else?
3 people. Tribunal panel, just 3 people, and 2 decide.
Impulse waiver. Okay. Alright, what else?
How the judgment.
The judgment itself lah. That basically Charles must pay Paul. Okay. Alright, so I guess that's about it. So same thing lah. Okay, how it will apply to Paul. Okay. Right now, so which part of this one is relevant?
Rule 42.
Hold on, sorry. Rule 42. Rule 42. Okay, Rule 42. Why?
Not less than 7 days. So, consider.
Okay, within the time limit lah, basically.
Yeah, within time limit.
So it's not less than 7 days before the hearing. Tribunal can consider any written representation. This one also important here. Okay, right? And then does not propose to attend the hearing. Okay, right? So these 3 things here lah, okay, which are important. Okay, all right. Okay, what else?
46. Rule 46.
Rule 46.
By use of electronic communication.
Alright, by use of electronic communication. Okay, what else? What else? I mean, here, anything else here that is important here? Well, basically,
provided can be heard
by all party members, basically this whole thing lah. Okay. Okay, what else?
49.
49. Anything in particular?
3 persons. Any decision by a majority.
3 persons by majority. Okay. Alright. Anything else?
61.
61 sub 5. Anything in particular?
It's just the whole judgment itself fulfills the criteria.
Yeah. Basically the whole thing lah. Okay, so I'm just gonna the whole thing. Alright. Okay, so now let's put it back to the thing. Okay, so 42 okay, is about why he cannot come, and then must give within 7 days. Okay, so this one is here. Alright, cannot appear. Okay, this whole thing here. Alright, then the next one is use of electronic communication and all these things is Rule 46. And so Charles gives his evidence by telephone through loudspeaker so that everyone can hear him, so no problem. Okay, then okay, Rule 49, 3 person, any decision by majority is basically here 3 people and 2 made out of 3 people and 2 decide in Paul's favor. Okay, and then the last one, okay, then the last one is Rule 61. The whole thing is basically the judgment itself lah. Alright, that Charles must pay Paul. Right.
I think my answer differs from the marking scheme in one aspect.
Wait, we haven't actually gone through the marking scheme yet.
Oh yeah.
Oh no.
I got see marking scheme, then 我就kanchiong了。
You don't see marking scheme first. Okay, we'll go through it together later. Okay. Otherwise, I mean, when you're doing yourself also, you shouldn't look at the marking scheme first until you are done with it yourself. Okay? Otherwise, it's like you're cheating yourself only. Okay. And then it make the whole thing pointless. Okay. Right? It's no different from like you do the SPM exercises and then you just go look at the marking scheme only. Do yourself first. After that, you go and check the marking scheme. Then you know whether it's correct or wrong. But I think this is more or less correct already lah. But so what is your conclusion here?
My conclusion is Charles must pay Paul.
Sorry?
The judgment stands and Charles must pay Paul.
Charles must pay Paul. Okay, right. Okay, now let's look at the marking scheme. Okay, now only we look at the marking scheme. Don't so kanchong. Okay. Okay, now, so I'm just going to go through this thing with you. Full development of the relevant sections. Conclusion, Paul will win his case. So, like what you say just now, okay. William's evidence can be considered under Rule 42, which you have, right?
God.
Yeah, okay. Pretty obvious.
This is the problem.
What's the problem?
Because Rule 42 says delivered not less than 7 days, ma.
So what's the problem?
Not less than 7 days is 8, 7, 8, 9, 10, right?
What means 7, 8, 9, 10?
Not less than 7.
Not
So
less-
must be more than 7, kan?
Yeah, like if it's more than 7, then only cannot lah, basically. Okay, that's the time limit lah. Okay, but the question again, I mean the scenario again, just very fast. It's supposed to be on 10 June, okay, it's to be heard on 10 June. That's why I see this part here is actually also relevant, 10 June, okay, so you need to mention this thing also. Then on 5th June, so it's definitely less than 7 days, it's on the 5th, it's on a, yeah, it's not even there yet, okay, still got some time, okay, I think it's still got 5 more, yeah, still got 5 more days before the thing is, before he's supposed to go to the employment tribunal, so no problem there lah. But you need to highlight this thing, okay, just not forgotten to highlight. Okay, so
he said not less than 7,
no.
He said not less than 7.
No less no less than 7 means that, okay, that no less than 7 days, okay, before the hearing, you see or not?
Hearing. Where's the hearing?
Okay, before the hearing. So on 5th of June, okay, it's like actually still got time lah, okay, still got time for him to go and do so lah, okay, because the thing is on 10, okay, alright, okay, so then after that, next one, 1, 2, okay, alright, within the time limit lah, so no problem there, okay, all is sent, okay, and within the time limit, okay. When Charles gives his evidence by telephone, this is admissible under Rule 46, so I think you have it there, also no problem there, as everyone in the room can hear it. I mean, this one you have to assume already, because you look back at the scenario, right? Charles gives his evidence by telephone through loudspeaker so that everyone can hear him. He says that so that everyone can hear him, okay, but whether everyone actually hears him or not, okay, is a different story, but you have to assume that he can already, okay, because there's no other point, okay, pointing that, okay, that they cannot hear him or anything like that, okay, alright, so you have to assume already. Okay, then next one, okay, so last part is the decision is valid under Rule 49 as it is made by majority of tribunal members and what it contains meet Rule 61. So this one here, Rule 49, nothing much, but Rule 61, this is something that you need to elaborate on a little bit, okay? Alright, okay. Alright, any problem with this before I move on? Just not the first one, so I forgot to ask you. Okay, alright, so yeah, there's no problem lah. Actually, this one generally quite simple lah. Okay.
Yeah, it's quite straightforward.
Yeah, quite straightforward lah. Okay, but this one came out in May-June 2020. This is the one that was cancelled. Okay, so
the COVID paper.
Yeah, COVID paper. Yeah. So yeah, imagine if those people set it for this time. Okay, is quite a bonus lah, I would say. Okay.
Supposed to sit for it, ma.
Yeah, supposed to sit for it. Yeah, but hopefully it will come out more or less like that as well lah. Okay. Right now, for question C, anything key points and all that first?
Prescribe completed claim form to the tribunal. Second line. Yeah.
Okay, here sends prescribed completed to the tribunals. Okay, where is it now? Okay, wait, I need to. Okay. Alright, he sends the prescribed completed claim form to the tribunal. Okay, anything else?
Rejects one, sends the other.
Okay, rejects one, sends the other with the response. Okay, this whole thing here lah. Okay. Okay, what else?
Sheena's husband represents her and she is admitted to the hospital.
Okay. Sheena's husband representing her because she's been admitted to hospital. Okay. Right. Anything else?
Tribunal gives Amir an hour.
Where is it?
Down.
Oh, here.
Yep.
Gives Amir an hour to present his evidence. Okay. Then some more.
Amir is still presenting. Amir is still presenting.
Still presenting, and then told him to stop.
Tribunal stop.
Okay.
Yeah.
Then finally,
Unanimous decision.
in favor of Sheena. Alright. Okay, so now let's look at the marking scheme. Sorry, not marking scheme. The source material. Okay, so which one is relevant?
Rule 8. That thing
Rule,
again.
rule 8. Yeah, definitely. Okay, so I just highlight here. Oh no, the whole thing become crap. Wait, what on earth? What the thing? Oh, it's the same color. Okay.
Okay.
Okay. Alright, just leave it like that. Okay, so what else?
8, 16.
8, then 16.
Why is it 16? Let me think.
Why I write 16?
My completes and returns the form. Why write 16? Response.
Sorry?
Wait. 15 first.
15 first.
15 first.
Okay, so for, anything in particular for 15?
15A, because one has been rejected.
Okay, good. Okay, what else?
How to submit? Why I write 16?
Yeah,
16
why?
relevant.
So 16 got or not first now? If 15 you say got, but 16 got or not? You have to decide.
With the response form, got.
Got. So got,
Got.
So why shall be in prescribed form, this thing here, is it?
Yeah, because after it was rejected, I think she got response form and then she completed it.
Okay, never mind, later we look at it later. Okay, then what else after this?
47.
47. Okay, why? Which part in particular?
47. Party fails to attend the hearing, which is Sheena, because she masuk hospital.
Okay, fails to represent. Okay, and then what else? Anything else from here? Anything particular other than fails to attend?
Any inquiries, it may be practical for the party's absence because her excuse quite severe lah.
Well, they didn't say, right, just say hospital only, right? But this is something that definitely you need to highlight lah. Okay, saying that maybe the reason probably is acceptable or something like that lah, because go into hospital. Okay, all right, what else?
For this one 47, right?
Yeah,
45.
45. Okay, anything in particular?
45. Time limits on parties presenting evidence may prevent from proceeding beyond.
Okay, basically the whole thing lah. Okay.
Yeah.
All right. Anything else?
49.
49.
Three
What?
people.
3 people. Okay.
Majority.
Okay. All right. Anything else?
No, finish it.
Okay. All right. Hold on. Okay. So now let's just do a quick review. So firstly is rule 8. Rule 8 started presenting claim form and all that. This one is a given. Oh, I didn't realize it's the same color. Sorry. So it's this part here lah, basically. Okay, I hope you can see my cursor. Okay, here, this whole part here. All right. Then rule 15 sub A, whether any part of claim has been rejected. Okay, it rejects one of its claim but sends the other. Okay. Then rule 45, impose time limit. Okay, when they are presenting the thing. Okay, this is not really following the sequence of the thing already lah. Okay. Time limit. Okay, 1 hour to present. Okay. All right. then after that rule 47, okay, fails to attend, okay, any inquiry, something like that, shall consider any information which is available, basically the whole thing lah. Okay, so this one is basically her absence lah. Okay, and then it's being replaced by the husband. Okay, then some more rule 49. Wait, it's not rule 40. Wait, okay, right. Rule 49. Okay, rule 49 is about the 3-person judge and all that. Here it didn't actually say whether there's how many judge, but yeah, it's something that you can actually highlight, no problem, because unanimous decision ma. Okay, that's made in favor of Sheena. Alright, so I think that's about it already. At the end of the day, so how will it be, okay, for Amir?
How will it be for Amir?
Explain how sorry?
He lost the case.
He lost the case lah. Okay, he lost the case, and is it appropriate or not, something like that? I mean, like, did they follow? Yeah. They did lah. Okay.
No, he lost the case, and the tribunal followed their procedures.
Okay, alright, okay, alright. Okay, now let's look at the marking scheme. I'm actually looking at the marking scheme already lah, okay, secretly, okay. Okay, alright, so full development, okay, so this question C, okay. Alright, so full development of the relevant section, okay, normal, oh crap, what is this? Okay, need to get back to this thing here. Okay, full development relevant section. Okay, conclusion: Amir's case has been properly conducted and decided. So this one is a little bit different, the conclusion, from the other two, because the other two is like Paul will win the case, and this one is Kate will have to wait. Okay, so it's like either win or lose lah. Okay, then this one here is whether or not the thing was done properly or not. But at the end of the day, also Amir lost the case lah. Okay, and of course you need to highlight the fact that whether or not things were done properly lah. Okay, so that's why I say the question is a bit vague lah. Okay, so you just need to try to look at every angle lah. Okay, right? The next one, he has sent the proper form under rule 8 and rejected, and the rejection of one part is allowed under rule 15, which you did talk about, right? Okay, so rule 8, rule 15, rejection. Okay, right, then the next part is okay, the restriction on time Amir has is valid under rule 45, but the hearing can proceed under rule 47 even though Hamish speaks for Sheena, and the decision is valid under rule 49. Okay, so rule 45 first is about the restriction. Okay, so which you did put, I think. Yeah, time limits. Okay, because it's given 1 hour to do it only. Okay, and then after that, rule 47. Okay, the replacement thing. Okay, which you also did put here, fails to attend to be represented. Okay, alright, by the husband. No problem there. Then finally, the decision is valid under rule 49. Did you mention about rule 49? Yeah, you did. Okay, good. Alright, so no problem there. Okay, but just to share with you lah. Okay, actually I remember I did actually discuss this question with other students before. Okay, physical classes lah, this one. Okay, that they actually say that, oh no, this is very unfair. Okay, to actually stop him, okay, from giving his speech, okay, while he's still presenting and all. But then the thing,
tribunal supposed to be short
okay lah, fine lah, different people got different perspective lah. Okay, but that student, she actually said that lah. Okay, but then my reasoning, okay, your reasoning is different from mine already. My reasoning was that well, he didn't actually say whether or not he presented more than an hour, so he could have actually presented more than an hour. Okay, and yeah, of course you need to highlight this thing lah. Okay, the 1 hour thing lah. Okay, all right. Okay, all right. So any problem with the question C?
No.
No lah. Okay.
可怜 Amir, but no.
Okay, so for this session, okay, we are just actually discussing question A, B, and C only lah, because data response. Okay, question D is essay. Your essay is quite okay already. Okay. Okay,
I never studied Tribunal yet. Cannot okay, God.